Many modern businesses and service organizations invest vast sums of money to establish easily recognizable symbols for their products. For example, children in many countries recognize the golden arches signaling the location of a McDonald's franchise. Such symbols are trademarks or service marks. The common law and statutes protect trademarks from as early as the 13th century in England. Proprietary rights in a trademark can be established through actual use in the marketplace or through registration with the Trademarks Office. Modern trademark law in the United States stems from the Federal Trademark Act of 1946, commonly called the Lanham Act. The act provides a method for obtaining federal registration for trademarks or service marks, superscript 20, which reads, "Note, however, that one does not have to register a mark in order to receive a property right in that mark." Returning to the text. As in the case of patents, the successful applicant must establish that the mark passes certain criteria, the most important of which is distinctiveness. Registration with the U.S. Trademark Office entitles the holder to certain protections and rights, among which is the privilege of placing besides one's trademark sign a capital R inside of a circle that indicates a registered trademark. Superscript 21, which reads, "Some producers place the symbols capital TM or capitals SM for service mark on their products, but those symbols have no legal status." Back to the text. The owner of a trademark can sue for infringement to prevent unauthorized use. Trademarks help to solve the problem of consumer ignorance about the quality of a product. When quality is opaque, the consumer can use the trademark as a signal of quality. Furthermore, trademarks reduce the cost to consumers of searching for a product with specific qualities. The principal economic justifications for granting property rights to trademarks are that they lower consumer search costs and create an incentive for producers to supply goods of high quality. Marketing in Eastern Europe before the fall of communism in 1989 shows what can happen without trademarks. State stores sold unbranded goods with generic labels: bread, shirt, oil, or pen. And a consumer would find one or two unbranded pens on a store's shelf, so he or she could not tell who designed or manufactured them. A purchase was a random draw from the universe of state factories. Because factories could not acquire reputations with consumers, they could not compete to improve quality. In contrast, trademark law enables a company to build up a reputation for high quality and credible advertising so it can compete with other companies on these dimensions. The general problem of credibility is central to information economics. Buyers of information generally cannot determine its value until they have it. To illustrate, a banker recently received a letter that read, "If you pay me $1 million, I'll tell you how your bank can make $2 million." The only way to make this claim credible is by providing the information to the bank. After the bank has the information, however, it has no reason to pay for it. Similarly, to assess the value of innovative software, a large buyer like Microsoft must understand how it works. After learning how the product works, however, Microsoft may produce its own version of the product rather than paying royalties to a small company.